Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. So next up, I would love to introduce Mark, who will then introduce our other speakers. Mark LeHocky is a mediator and arbitrator with a nationwide complex dispute practice affiliated with ADR Services, Inc. He previously served as a senior executive and public company general counsel at both Dreyer's Grand Ice Cream, Inc. and Ross Stores, Inc., as well as working as part of the senior worldwide legal team at Nestle. Prior to his general counsel days, Mark spent 20 years litigating intellectual property, antitrust, class action, and other complex disputes for clients ranging from startups to Fortune 100 companies, including Apple, AT&T, Dreyer's, and MetLife. Mark's been repeatedly named a best lawyer in America for mediation and was voted Mediation Attorney of the Year for San Francisco for both 2024 and 2022 through the Best Lawyers Attorney Peer Rating systems. In addition to training the Nestle International Legal Team in dispute resolution, Mark developed and taught a course on mediation advocacy for UC Davis School of Law. And today, Mark still teaches at UC Berkeley School of Law on the intersection of law, risk, and management and decision-making. His Berkeley Law course, Managing Difficult Legal Conversations, examines effective and ineffective legal events, along with strategies for improving outcomes for lawyers and their clients. And here at ADR Services, Inc., I have the pleasure of working with Mark as his case administrator. So if you have any questions about his calendar, please feel free to reach out to me directly. So I will hand it over to you, Mark, to introduce our other fabulous panelists today.
So thank you, Katie, very much. And I'm sorry that went so long. Most of it was true, though, I think. It's a pleasure to be here with Christine Kurek and Gian Houck. And I'd like to describe their backgrounds a bit. So Christine is a former in-house attorney who's also started early in her career doing plaintiff's work, working for a plaintiff's firm. Has a great multifaceted background. She's now spending her time doing ADR work, and you'll have contact information. Please reach out to her if you have it matters, and most of us do. But in addition to that work, she's done a lot of work as part of different organizations, and part of her success is being named Corporate Counsel of the Year in 2023 by the LA Business Journal, and one of 2020's top 50 diverse leaders in California. And today, among other things, she's also sits on the United States District Court for the Industrial District's mediation panel. So welcome, Christine. Now, Gian Lee Houck, I've known for a number of years, and was so thrilled to reach out to her to have us join this conversation, because Gian epitomizes effectiveness as an advocate in mediation. She is today a founder in a firm that is called the Houck firm, with her husband, also a trust and estates litigation attorney, where they emphasize both employment and elder abuse cases, among other things. She's also serves on the board of directors of the Women Lawyers Association of Los Angeles. She's the political chair at the Women's Caucus for the Consumer Attorneys of California, and other organizations. And I'm particularly thrilled that we have 2 people from different backgrounds, although overlapping to some extent in the employment area, but working in different sides of a lot of issues, which I think makes for a better, broader conversation. As you heard, part of my background was being general counsel for various companies where I managed, and I now mediate a broad range of issues besides employment, especially a lot of in trade secret, intellectual property cases, because that was my litigation background. The point of that is a lot of what we're going to talk about, we might mention an employment example, but most of the time, and I think Christine and Gian will agree, what we're talking about straddles a broad array of types. So, but before we also jump in, I do want to thank ADR Services and Katie Jones for the excellent work helping to organize us. I do recommend you look at the other programs ADR Services provides. I think they're all free. And as with this one, it's a great combination of very talented people who come from different backgrounds, and there's always value in sharing perspectives. And also, you'll see we're going to go light on slides and spend most of our time in conversation. But we will, just to set the stage for the conversation, we'll talk about quickly the discussion items, and then this will disappear because I have trouble myself seeing the other speakers when we're all little heads off on the right side. But you can see what we're going to talk about. Again, the prompt for this was some preparatory conversations among Christine and Jean and I talking about what works, what doesn't in the mediation process. And lo and behold, the term preparation kept coming up. The more prepared, the better. And we will keep coming back to that. But practically speaking, what does that mean? And I think what we really seized upon is that there's really 3 stages of effective mediation preparation. We all know about preparing the mediator, writing a brief, and all that. But as I think we all agreed to, and we'll jump into now, there's stages before the mediation session, which I will argue are as important. But let's kick off there. Jen, do you want to start in? We've talked about the issue of the different phases, and then we'll all add to these different topics.
Sure. So I think one area that I will say that earlier in my career that I did not pay enough attention to was preparing my client. And now I find that it's really a critical part of the mediation process. And I will tell you that the more prepared my client is and the more trust that I build with my client in the process, the better the outcomes. And outcomes meaning the strengthening of the attorney-client relationship and also the settlement outcome as well. So I represent plaintiffs, so vast majority of my clients have never been part of the legal system, and they have a healthy fear of lawyers and everyone involved in the legal system. And so I start with the very basics. I meet with my client at least a few weeks before the mediation, and I just tell them exactly what to expect from the moment they log on to the mediation. A vast majority of mediations are conducted over Zoom these days. I think I've had one in person since the pandemic started. So I like to prepare them on the same platform that they're going to be using. So I help them. Some of them need help logging into Zoom and where all the buttons are. And so I do that. I help them find a good spot in their home to set up where the lighting's going to be good. I make sure that, they can hear me and I can hear them. And then I just walk them through what to expect in terms of, typically there's a discussion about the facts and the evidence. Sometimes there's a discussion about the law. And then there's of course, the discussion about the numbers. The one thing that I highlight for all my clients is, and they're instantly, you can see that in their body that they're instantly relieved, is that they're never going to have to see the other side. Okay. Most of my clients who have gone through some sort of workplace abuse, that's the thing that they are scared of the most. And so once I tell them that, they're relaxed and they're comforted by that fact. I think, if you don't put that time in to talk to them of what to expect, they can show up really anxious, and that can lead to bad decision making. It could also lead to leaving a bad impression for the mediator, because when you're anxious and you're scared, sometimes that can manifest into like anger, withdrawal, all of these different things that are, just not the plaintiff or not your client presenting in the best way that they can. So that's really important to me. I think that preparation for your client also gives them comfort that you are on their side, right? You are there to fight for them, and strengthening that relationship will help hopefully have them listen to you at the mediation.
That's great. So Christine, working primarily, it sounds like, at least in your recent career in in-house role, most of the time you're on the defense, not always, but most of the time. So, but thinking about the same issue, the client preparation, it may not be the same, but where's there overlap? Where are there differences from your perspective?
Yeah, I think there's overlap, but I think there are two things. Number one is determining what your goals are for the mediation. And number two would be making sure that you've sufficiently investigated what you need to factually and legally, of course, before you go in. So starting with the first one, goals for mediation is really important. There are times that you may have the goal to settle for a variety of reasons. So what I see as a mediator is that, the plaintiff may really need to settle because of an important thing happening in their life and they need money, frankly. Or that maybe they don't want to have to tell their story in a courtroom, very dramatically. It's something that's been traumatic and they want to tell their story here, but be able to move forward. On the defense side, it's oftentimes setting expectations within corporations, making sure you have appropriate authority, and really working with the team so they understand if it doesn't settle, what does the future look like, and that's okay. It's just part of the process. So that I think is critically important. The other thing that I see as a mediator is people who oftentimes maybe haven't sufficiently developed their case when they go to mediation. And so, for example, I had a reasonable accommodation case, and the defense hadn't really built out their timeline of the requests that had been received by the defendant from the plaintiff, how those had been addressed. And so they weren't adequately able to address some of the claims from the plaintiff in that mediation and really get to the nut of what the value of that case might be. And frankly, what that led to was a loss of time. There was a lot of time in their room spent making phone calls to people who may not have been available, which is really difficult, for all parties because it's kind of dragging on. But most importantly, I think it led them potentially to undervalue their case when they walked in the door. And so it took them some time, I think, to develop some of those facts. They ended up settling after mediation, which I think you and I see oftentimes. People sometimes think they're going to be one and done in mediation, but it really is a process. And so if you can set those, it goes back to goal setting. If you can talk to your client about what that might look like and how to work through the process to still get to resolution, mediation is just part of that tool for the day. So.
No, that's great. That's great feedback. If I could add a couple, because of working not just in the employment area, class actions, but also IP and other business matters. Absolutely asking the questions up front, what are we here to accomplish, is huge. And you might think you may have a sophisticated client or a company that's been through litigation before, and hence they know everything. But with all due respect, don't assume that. In asking your client, what are we trying to accomplish, besides we want to win or we don't want to lose, is really helpful. I know that from being in positions, both in my GC role and litigator role, where I stumbled upon situations where I go, no, the real goal is not, we didn't need to win, we need to make this go away, including examples. One large patent infringement case I inherited, we were being sued for, where I, among other things, stumbling around asking the client, how big is this? What is this worth? And then I'm being told, oh, we're thinking about actually getting out of that little business. It's a small piece of a bigger company's business. And I said, well, if that's the case, we should be thinking about this differently. And we're on the defense side, but once we realized it's not that big, and besides talking about diversion of time and energy, it really was a path to get it settled very quickly. So sometimes you get called when you're the attorney or the in-house department, and it's just, okay, we've been sued, we have to go not lose. Or we're, they call Jan and we have this claim, so we have to go win. Talking about the objectives broadly is really, really huge up front. Very good point. On the anxiety point you mentioned, Jan, too, the other thing I was going to add is I always think it's helpful to remind the clients, and I do it when I sit in the mediator's chair up front, right up front, especially if they're civilians, is to say, if you haven't been through this process, I want to just quickly identify what my role is and what it's not. My role is not to cajole, force you to do anything. My job is to help you understand the range of options here and help you make the best decision, you, the individual, you, the corporation. And I think that helps a lot. And obviously then the work is about helping them explain those options in a way that, is useful to them. So that's great. So we threw out another subtopic, which is preparing the other side. And by the way, when I've had this informal conversation with other people and I say the same thing, they say, what do you mean prepare the other side? They're the other side. Why would we want to prepare them? We're really talking about something fundamentally different. Jan, do you want to address that first?
Yeah, this is also something that has evolved for me throughout my career. And when I first started, we were always so secretive about everything. We never shared briefs, we never shared information beforehand. And if they didn't share theirs, we're not going to share ours. And now that's changed. And because we've seen results where, for whatever reason, the message isn't getting to the decision maker ahead of time, whether it's because the defense attorney or the other attorney isn't sending the right message, doesn't have the information to give, whatever it is. I know that if I share my brief early and I share all the, you have to make case by case decision on what to share. Some things you may want to hold confidential but the vast majority of things I do share. And for the purpose of making sure that it gets into the hands of the decision maker. And a lot of times it's not just one person, right? It's like multi-layers of authority that they need to go through. So I think as for people who have only represented plaintiffs, that might not be intuitive, right? You may think that by sharing it, you're letting something, you're showing some sort of weakness or you're exposing yourself. But really, there's a lot of logistical hoops sometimes. The phone calls can't be made in like a day either. So I try to share my brief at least as early as I share it with the mediator, which is a week before usually, sometimes even earlier, to make sure that they can get all the people in the same room together. And so they can set where they think that the case should settle at the right authority.
Yeah, then that's excellent. And I just want to jump on that to repeat. Timing is important. Mediators, I'll use my example. I always ask, please send me the brief a week early. It's not just because it helps me to plan for that time, but it allows for digestion and follow-up calls, which usually take place between when I get the brief, when that happens. But as importantly, Jan, you struck the key thing, which is don't assume when you have the mediation session that the people that are showing up have all the authority that they may need, because they have relied upon maybe their advisors to set the parameters before that time. So if your case is different, bigger, the exception to the rule, the reality is we all look for patterns. We look at something and go, oh, it's like this, so it's like that. This one may be that exception. I remember vividly a plaintiff's attorney that sent me a brief, and I called him and I said, do I have the calendar wrong? It's not for 6 weeks. And he said, oh, no, it's 6 weeks. But my case is not the standard case of this type. It was a horrific case of racial mistreatment. And he knew his case was different, and he wanted it to get to the decision makers, in this case, probably involving not just a corporation, but an insurance company, which I thought was brilliant. Now, so they had that opportunity to have multiple conversations. Christine, your experience is similar?
It is, both being in-house and as a mediator. And I'll tell you, I just had a mediation yesterday where we ended up wrapping a little bit early and agreeing to come back and have discussions around settlement values, because the universe of documents shifted between when the briefs had been filed and when we first scheduled mediation. And so even though we had done a pre-mediation call, It was basically the classic scenario where once the plaintiff had, it happened on both sides, but once each party had started discussing with their client to get ready for mediation, of course, that often happens at the last minute, and they learned more information and realized that they weren't playing with the same deck of cards, basically, and it was a billing dispute. And so they agreed they would go back, and a week from now, they're going to go ahead and connect again to make sure they do have the same documents, so they know the proper valuation so that they can then move forward with the discussions around settlement. So, similarly, I had a PI matter. They didn't produce the video of the car accident that they had from the dash cam until they were in mediation, which is not as, mediation by surprise doesn't work well because people are human. They need time, as you mentioned, Mark, and I think Gian as well. You need to digest that information. And then in addition to that, if you're a corporation, the insurance company in a PI matter had only come with a certain amount of authority, assuming liability was they denied liability, of course. They saw the video, they needed to recalibrate, and it was more than just a phone call that could be made. So that's another one that I think this is just the beginning of the process. So I 1,000% agree with you. There's another point that ties to it as well, which is I'm always interested to know whether or not parties have discussed in advance settlement value, because sometimes people come in with mismatched expectations, or frankly, maybe particularly in employment law, somebody came in initially with a demand letter and they had asked for a certain amount of money to settle. And then as they develop the case, they realize that the case may be worth a lot more and they have more information, or it could go the other direction as well. But typically it's harder to manage expectations when the case value goes up. And so if you're dealing with an old number when you walk into mediation, that's really challenging because, typically corporations are pretty upset when, they don't have the right valuation and the right authority. So I think it's everything that both of you said. If you don't have the adequate time to prepare through these developments of facts and authority and the like, you just won't be ready to settle your case at the right value.
Well, and I think hopefully our audience is starting to get part of the common thread here is about helping people set appropriate expectations. In fact, I had one wonderful staff counsel who blurted out in the meeting, "The number doesn't matter. It's how people feel about the number that matters." She was right. Having been involved in a lot of cases that get fully litigated, even where we quote unquote win by not losing, or for the plaintiffs who win, there are situations where people go, "But did we have to do all of that?" Or if you get a very, very small adverse award, people think that's outrageous. At the other end of the spectrum, you get a very, very good result that people have trouble reconciling to it. So the thing we're talking about is helping that decision-making process, which again takes sometimes multiple actors have to be involved. Bigger the organization, more likely. Insurance companies involved, more likely. And allowing time for that. I may have shared with Christine and Gian before, but one of the most memorable courses I took as an undergrad, typical generic poli-sci major, was a course at the medical school, UCLA, the only class available to pre-med students on the topic of death and dying. Taught by a contemporary of this famous Swiss psychiatrist, Elizabeth Kubler-Ross. And you've heard probably of her stages of dealing with grief, where people go through these mental stages. Absolutely fascinating course, absolutely fascinating topic. What does that have to do with what we're talking about today? Guess what? You can be in group session meetings in corporations, executive teams, and the like, where you will see that drama play out. The absolute, this can't be happening, rejection, to blaming, to giving up. It does happen more often than not. I've seen it with my own eyes. Recognizing that lawsuits are generally not good news, not good developments, often surprising, often negative. Be aware that people are processing and that organizations are processing. And you need to help them by again, allowing time for that processing, what we're talking about, get the information to people, both the good, the bad, and the ugly early on, so the expectations are in the right spot. That's when good things happen to mediation. My goal when I was the client, the general counsel, was to go to all the mediations, never needing to pick up the phone and call anybody back home in corporations, because I had already done the pre-work to say this is how bad it could be, this is how good it could be. So you have people all on board about the process, but that takes time. So let me go back, because Jane, you mentioned a key issue, and I want to get Christine's input too, is the issue of the briefing, because we've all run into some kind of tired thinking about that, about, oh, we never share our brief, or how do you convey to the mediator what you want, and also what do you want the other side to see? So let me start with you, Jan, about that.
Yeah, I mean, my briefs generally follow the same format, right? But I make a point to include in the brief a section about my client. I include pictures about my client and just like generally who they are, to try to make them more of a human being, a three-dimensional person for everyone involved. I don't know how much it works, but I like it and the client likes it. And I'm hoping it does something either subconsciously or consciously to all the people involved, that it's a real person. And then I pick my best stuff, right? I don't think any mediator wants, hundreds of pages of exhibits of things that are not in dispute, right? And so I, pick my best things. I screenshot the things I really want them to focus on. And I try to write as concise of a brief as I can, because I know everyone's busy and no one wants to read anything more than they need to, right? And I also include video clips. If I have good deposition testimony, I will clip that video and send it to the mediator and send it to the other side too, even though they were there, right? So they can show their client, look, this is how, because sometimes it doesn't come off on the pages as well as it does in video. So I'll send that over too. And then depending on the case, I'll also give my mediator like a cheat sheet. Here's a chronology, a one-pager chronology that you can refer to, a one-pager like cast of characters if there's like so many people to keep track of. All of these things I prepare in advance so that everyone is kind of has all the tools that they need to make good decisions at the mediation. Hopefully good decisions that benefit me and my client, right? So yeah, that's kind of what I do in my mediation brief. Obviously, if there's a tricky legal situation, I will have a discussion about that. If there's not a tricky legal situation, then I don't bother the page space about talking about the elements of discrimination or whatever it is that I know that the mediator already knows. My 2 cents about briefs.
No, that's great. Christine, yours? I want to throw in a couple, but
no, I agree. Look, particularly when I was in House Counsel, I always wanted to make sure that the other side was aware in particular of what any key witnesses might have said. Now, of course, you always have to think through, depending on where you are in the discovery process, whether or not you're also giving them sort of, a roadmap for discovery. That's always something to think about on both sides. But if you're already through discovery, it's sort of irrelevant. But I think that the crux of that is ultimately just making sure that in a minimum, the other side is aware that you do have key witnesses and support, because it's one thing when it's he said, she said, but if you have other evidence to buttress your claims, that's going to be important for the plaintiff to know. And there may be some credibility gaps that need to be addressed as well. So, again, I think you don't want to mediate by surprise, but the flip side is, of course, thinking through your overall case strategy. So.
Yeah, I always try to get witness statements ahead of time, but I don't share those. So I share them with the mediator, so the mediator can at least convey it to them that, hey, they've got these witnesses that are lined up. Sometimes I can't get signatures on some witness statement, which is obviously, lesser evidentiary value in the mediation, but I will still let the mediator know, look, I talked to them, I'm confident I'm going to get a signature, or this is what they're going to say in deposition. And then, give them the tools that they need to do their job in the other room.
Great. Yeah, and just to pick up on what you mentioned before, there are certain situations where people debate, do I share my brief or not? My polite pushback as the neutral is, if this is really helpful to your case, why aren't you sharing it? And there are situations definitely where people will say, well, I want to keep this secret in case the case doesn't settle. But the best thing I think we can do is kind of challenge that notion, which is if it really matters, use it now. And the corollary to that, if it really matters, what can they do about it later on? That what's going to change it? They can deny it, they can try to rebut it, but you're going to have to be putting it out there anyway. So I politely counsel people to go, if it's going to help you, good. If it's really important, why is it in your back pocket? Aren't you better off sharing it now? And there are exceptions. I remember during my litigation days doing antitrust work in particular, there were times where I could say, I don't think they understand this problem with their case. I don't want to educate them during the mediation. So I'm going to take this deposition and then we can have a conversation, or I'll file a summary judgment motion. But
Can I say one thing?
Yeah.
Well, I'm sorry, Mark.
No, I was just going to say, but I can count probably on one hand the times where that was really true. We can't talk until I do these things. The rest of the time, my point, Jan, is most of the time, get it out there, and then you figure out what you're going to do with it. Oh, please.
Completely agree with you. Most of the time, I think, there's nothing they can do about it, but, you just got to look at everything with that eye. One thing that I did recently, this is something that I just tried, because sometimes you got to be creative, right? And this client was so great and so good about, she was so stoic though, right? But if I got her to talk about what happened to her and how it impacted her, it just was so raw and real. So I asked her to write like a victim impact statement. And I recorded it on Zoom.
Mm-hmm.
And it was so impactful. And like, I'm getting chills right now. And everyone who watches this thing was in tears. I did not share that with the other side, but I shared it with the mediator, and I allowed the mediators to screen share a portion of it. And we had clipped a portion of it ahead of time. And she played that for the other room. Mm-hmm. And she said it was very effective, because I think that in our line of work, in these employment cases, it can, I think people can get jaded. And the people making the decision maybe in the other room are like, okay, yeah, emotional distress. Every plaintiff has emotional distress. I remember once I had my opposing counsel, he was a defense attorney. He later became my client, and years later. And as a client, he said, when I was a defense attorney, I will tell you, I thought emotional distress was BS. But now that I'm here in this position, I know that it's real. I was like, yeah. I can see why, you see it over and over again, and you don't really see the impact. You can get that way. So I thought that the video was really impactful to show truly how this affected this woman. And so, just a little thing, if you want to be creative, I thought that was really helpful.
Oh, no, that's great. I think it goes along the same line of what we're talking about, setting appropriate expectations. In this case, educating the other side about risk, reward, benefits. So helping them help their client, meaning lawyers, helping the lawyers on their side help their client make an informed decision about how good or bad something is. There's a great member of ADR Services, Judge Paul Beeman, who always made the great point. If you believe you're a good advocate, as we all do, or we shouldn't be doing this work, you should be advocating to the other side your best position, not just to the mediator, but to the other side. If you've got a really compelling position, case, evidence, show it to them. And he was always doing that in response to people saying, oh, we don't show our brief to the other side. Why the heck not? It's Paul's response, and he does it much more brilliantly than I'm trying to do. But you want to change their minds. Obviously, we want to change yours about the value. And that's all about the expectation setting process. To wait until the day of the mediation and say, oh, by the way, we have some other stuff we're going to put out there. Sometimes it works brilliantly, but again, sometimes it's harder than it needs to be, because you haven't given the other side whatever that consists of, multiple layers of decision makers, sometimes carriers, sometimes individual plaintiffs, the chance to really digest that. And that includes an employment area where the employee's position is, and I was the stellar employee and never did anything wrong, and the defendant tells me separately, but here's the record of major violations and other things. Why don't you show that to them, not just the plaintiff, but the plaintiff's lawyer, so they can factor it in? It's all about the same thing. You also mentioned this issue about shared briefs versus side briefs or separate briefs. But I've always counseled people is share your core brief, the reasons we're talking about. If you need to tell me something you really don't want the other side to say, you really think it's going to be helpful, please don't just call them bastards in the side letter. You can do that, but that's not as effective. If there's something really strategic, significant, put it in a side letter, right? You can still educate the mediator, but you don't have to inflame the other side. Christine, your further impressions on the briefing process and how to approach that?
I was actually going to mention what you just said, which is I'll oftentimes encourage people, if there's something they don't want to put in their brief for the other side, even if they don't want to write a side letter, if they want to just bring it up with me in the pre-mediation call, that's the opportunity to do that. So I always encourage, people who say, no, I always do a confidential brief. I'll just say, look, why don't you write it? Take a look at it. And if 90% of what you have in that brief you can share with the other side, go ahead and share it. Take out that little tiny piece of information that you want to discuss with me separately. And then it meets both goals, right? So it's exactly what you said. So I 1000% agree with everything you said. And Gian, I love your idea of that victim impact statement. I think a lot of times there is sort of that human factor that needs to be re-injected into it. And I'll tell you, when I was in house counsel, I can't tell you how many times, there were tears shed in my office. And, you sometimes really do need to relay that back to people to let them know, where things land and prepare them appropriately for what moving forward in litigation would look like. And sometimes that's just, part of the risk of litigation is the human impact of how difficult it will be for some parties. And so you really do have to weigh that, particularly, on the plaintiff side, it's hard for the plaintiff, but it may be really hard inside an organization where if for 3 years you're constantly talking about this and stirring it back up, you may do so much damage to a team and a part of an organization that could be incredibly critical to your, P&L. So those are all things you really have to think about.
Yeah, the other thing about the briefing that when I was teaching at Davis a few years ago, I told my students, when you're writing the briefs, I'm not going to grade you down for much. I will grade you down, though, for using words like specious, baseless, and any use of invective undermines your ability to communicate with the other side. If you want to call them names, put that in the side letter to your neutral. By the way, we won't give it much weight because it doesn't really matter. But if you really, and I've had this happen more than once where people say, but my client really thinks we have to say A, B, and C. I go, do that. Okay, do that in the side letter to me. Don't send it to the other side, because guess what? Again, going back to the obvious, this is a consensus-driven process. Nothing happens unless people agree, and people don't agree if they don't listen. And they don't listen when they're the subject of attacks. If anything, it results in, I know you are, but what am I kind of dialogue. So making that communication, I don't mean to at all reduce the importance of good advocacy, but good advocacy is telling a story that's going to appeal to the jury or the judge or the arbitrator, and that anybody should be able to look at and go, oh, yeah, I don't really want to try that case.
Yeah, and if you're doing all this name calling, I think it just shows that you're not prepared to try the case too, right? And so, like, you would never go in front of a jury and say, those guys are, these lawyers are jerks. I mean, you get in trouble by doing that, right? I think that if you tell a persuasive story, right, and you have the evidence, you can show the other side that you're a serious person and this is a serious case. if you do the name calling, I think it just, like you said, Mark, just undermines your credibility. And yeah.
Well, in the other piece, we've been talking about the setup, obviously the conversation with the client, the briefing process, what gets sent to the other side, what gets sent to the mediator. The other thing I wanted to get your thoughts on it, but I was obsessive compulsive when I was doing my general counsel work, was the importance of direct conversations with the attorneys on the other side. And not because it's just we're all good friends. In fact, I used to always say we have a 3-conversation rule. You have to have 3 conversations on the other side before you go to mediation, because the first one will probably not be successful. They're going to be worried. Why are you calling? Or you trying to steal their wallet? But if you persist and say exactly this point, we want to be prepared too for the mediation. If you're telling us the case is different than we think it is, tell us, help me understand why. I'm going to tell you why I disagree. You can't do this as one-way street. But I want to make sure we're prepared. I want to make sure you're prepared. You and your decision makers are prepared. And that doesn't happen by sending demand letters and responses or nasty emails. I'm personally of the belief that those kinds of documents are just self-serving statements that don't advance the ball. It's really a matter of picking up the phone or turning on Zoom that allows for that, what are we missing here conversation. And oh, by the way, in both plaintiff's work and defense work, there have been a couple of times where, oh, we didn't know that, and it made a difference. And don't you always want to know that as soon as possible? If there's a fundamental weakness in your case or your defense, factor it in. That allows for that conversation. But what's at least my observation after 26 years doing just the neutral work is the number of times people show up, and I usually start out or in the pre-calls say, what conversations have we had before today? And it's still an alarming percentage of people that go, none. That's what you're here for. So my 2 cents is the briefing critical, that sharing it with the other side's critical, but the direct conversation helps you be as effective as you can be when you show up. But Jan, agree, disagree. It's okay to disagree. We don't all have the same view here.
I agree, period. And I find that, less than 50% of the time, well, no, that's not fair. I'm often disappointed, I guess, in that conversation, because I like you said, I always start everything in by saying, hey, if there's something I don't know, you have the universe of documents. I usually have my client and what my client is telling me, and the defendant has everything else. And so I'm like, if there's something that you need me to see for me to properly evaluate this case, please share it, right? Please share it now. And I think that a lot of the defense attorneys thinks I'm trying to pull a gotcha on them or something, instead of being like, hey, I don't want to get stuck in a case either, if I don't know something, right? And so, but yeah, I always try. And I do think that in the cases where I've developed a rapport where we are cooperating, right? Let's try to figure out where the disputes really are and how, and then we'll get a better sense of what the case is really valued at, right? What the real risks are, what the real, all of those things. And those cases are always the ones that resolve, I think very fairly for both sides.
Well, the reason I said I just watched an interesting documentary about a making of a movie, a sci-fi film called Galaxy Quest. Highly recommend it. But it was funny to watch, and they brought back that one of the themes for the movie is this term, never give up, never ever give up. Never give up, never surrender, also from Churchill. So that's why I said 3 conversations, folks. Because first time you call, they're going to be hesitant. But the persistence matters, and of course, tied to willingness to share matters. I mean, Christine, how did you think about that in terms of preparation for
I actually have a question for Gian. Do you include a demand in your brief typically?
Sometimes I wish I could have a better explanation about why I do and why I don't.
Okay.
Sometimes I want to wait to have a conversation with the mediator. Because oftentimes I share my brief, but they don't share theirs, right?
Yeah.
And so I want to kind of get a sense of, what the feeling is about, if I'm misvaluing something or whatnot. But I think generally it is probably good to give them a number that they can chew on before.
Yeah.
But typically before we get into mediation, we've had at least one round of something, right?
Yeah.
Or at least I've presented a demand, and then they typically come back and say, let's mediate instead. So there is a number floating around there.
Okay.
So oftentimes if it's later in the litigation where we're mediating and there's been an earlier demand, I will typically say that number was that number back then. Doesn't mean it's a number today, but I might not give the number today because typically the mediator is going to tell me, please start with this number. And then I will say, okay, fine, I'll start with this number. And that's usually how it goes.
Interesting. And, as I'm listening to you, it's so funny because all these things that we've talked about, these are the things that set you up for success up until this point and will influence your decision here, right? It's exactly what you said, which is if you've had some discussions like Mark just mentioned, then it's not as big of a deal to keep talking about a number and to know what your opening demand is and to share it in your brief. On the other hand, if you've not had those discussions, maybe because the other side hasn't wanted to engage, I fully understand why you would want to take advantage of having potentially an evaluative mediator who can help guide you, particularly once they know the other side of the case, to what an appropriate opening might be. And you might disagree with them and still want to do something higher or lower depending on your client's needs, but probably not lower. But ultimately, you do want to set yourself up for success along the way, and that gets you to the briefing and the conversations, Mark. And for sure, I had always asked as in-house counsel, sometimes I would handle the cases myself. Many times, by the time we were going to mediation, we would have hired outside counsel. And I really enjoyed working with one person in particular who was a consistent outside counsel for us. It was an advantage that she knew us as a client, but also she had that temperament where she was able to have discussions with people in advance. And there were many times that we were able to just settle before going to mediation because she was able to have those dialogues. And I'm always a big fan, even as a mediator, I'll say to people, if you can do this yourself, great, it's better for everyone. But I'm here to be a tool for this process and to help you along the way. So I 1,000% agree with what you guys have been saying. And my personal preference is if the parties have had those discussions, I do like to see a number in the mediation brief from the plaintiff, because to your point, when you said to give them something to quote, chew on, I think it's incredibly helpful for the other side to know where you're coming in. It also ensures in some ways that the plaintiff won't go up when they get in the room, which can be really damaging for discussions. And it gets to another point, which is, authority, especially if you have insurance involved. You really have a lot more steps to go through and a number of hoops to jump through to get to the right place. So I'm an advocate for being really transparent on that.
So one thing I will do if I don't actually put a number in the brief, one thing I always do is I will do a breakdown of damages, right? And so I will talk about what I expect lost wages is going to look like, what I expect emotional distress is going to look like, what all of these different things, and they can do the math, right?
Right.
And so from there, they can see kind of where I value my best day in court, right? And then, we can figure out what the first number should look like. But I always say the first number doesn't matter. It's the last number that matters.
Well, and hopefully in the preparation conversations with a client, which sometimes I think is done, sometimes not entirely, the client is told, by the way, we're going to ask for this. We're not going to get this. Or the reverse of that is, yeah, we're going to start out there. They're going to start it by saying there's zero value in the case, but we're going to, of course, have to pay something. is that's part of the client preparation. And we're all, and again, the same thing we're talking about is setting reasonable expectations, helping the other side set reasonable expectations. The other thing I'll add to it, and this goes to not just the briefing process, but when you have an unusual situation, sometimes it happens in the real world that the people that are showing up as the quote unquote decision makers on one side may have some part of the problem, may own part of the problem. Now, this is a generic statement I have to make on purpose. Can't talk about specifics, but there are situations where the decision maker may have been part of how this thing got off track the right way. Feel free, if you're counsel, to call up the mediator and saying, here's one of the things we're going to have to deal with. We're not going to shine a light on anything. That's not the job of any good mediator, but to say, here's what I have to work around. And sometimes here's the client that I'm coming in with, and I want you to understand a little bit more about them, their background. And by the way, this isn't, again, just about employment cases. Competitive cases, there's often animus that is equal to or greater than. Even what my family law friends say, oh, you don't know, Mark. I go, yeah, I do. Yeah, I do. It's real. So in addition to your briefing, in addition to educating the other side, you can help your prospects by reaching out in advance to the mediator and saying, let's talk a little candidly before anybody else shows up. At least my experience, that's been helpful. So we have some great questions, but I want to pause those for the next several minutes so we can hit one more topic and then go to the questions from anybody who wants to hang around longer. And that's to what happens if you go to the mediation and it doesn't resolve that day. In terms of your thoughts, because I've unfortunately, by a lot of training, had a number of people say, oh, mediations are essentially one and done. We either mediate and settle, great, or we mediate and don't settle, it failed. But I'd love some thoughts from the two of you.
I mean, I personally always view this as a process. So ideally, you'd like to get it done the same day. That's what we're striving for as mediators. But I fully appreciate that as much as we've talked today about preparation, that doesn't always happen in the real world the way we'd like it to. And so as a result, it may very well be that more information is needed. I've had scenarios where they've decided they want to go take one more deposition and then come back. And so there are many times that the process will follow, and the process can look like a number of different things. I will always follow up as a mediator, and I will follow up by email, I'll follow up by phone call, schedule another mediation session. But I think most critically, it goes back to what you were talking about, the two parties communicating, because if you do need to go seek out some additional information to then get to the settlement stage, that's where the two parties have to participate to get the depo done, to get the documents exchanged. And it doesn't do any good, in my opinion, to, someone will say, well, the plaintiff will say, I'm worried they're going to drag it out and never deliver the documents to me, and we'll hit the discovery, cutoff. Well, that's again where you've got to keep working that case and keep moving it forward. And I can do what I can to help you as a mediator to get people to agree to have touch points to come back together again. But it's still litigation. You still have to manage it. But this is where, as mediators, we can be helpful in that process to facilitate. And I've even had a plaintiff's attorney in the wage and hour space just point blank say to me, I wish more mediators would contemplate in their agreements that they're going to have a tail to the matter, because there's usually follow-up work that does need to be done. And I'm perfectly happy to pay for that person's time. I just want them to have the expectation that, they're going to need to complete it. So that's a long-winded way of saying, start with the day, do the best you can for the day, but know that it may just be the beginning of a process that may take a little bit longer and a few more stages to get to the same place. And that's okay if that's how your case is situated.
Right. Well, and I appreciate that, Christine. So again, talking to my friends who do family law mediation, we talk about what we do in civil cases, and they sometimes turn back and go, you're all nuts. By the way, I think they're right. Meaning, I think we developed a model 30 some years ago when private mediation practice took off, mostly at the time ran by wonderful people, formed organizations, most of which were retired judges who were familiar with the mandatory settlement conference, which was a marathon session. You usually didn't attempt until you're right before trial, after people had done all the work, sometimes invested, typically over-invested resources and time. And it was a marathon session to go from start to finish, again, without pre-calls, without prior conversations and the like. I think a stepped approach fits many situations, not all of them by any means, maybe not even most of them, but I deal with mega cases where you need to have a series of stage conversations, and there's nothing wrong with that. That's a good thing, to get to the right spot. So part of what we can do as advocates is think creatively about our dispute. Is it a standard matter where we just do this that we've been talking about this hour, and that's fine? Or does this need slightly different attention? Obviously, the bigger the matter, the more resources are warranted. To really look at is doing it through start from finish in one day makes sense, or is there a way you can stage it to get to the right result? It's not about whether we win today, it's whether we do this or we do that, which can be enormous in time and energy and diversion. But Christine, when you think about when it's what, oh no, Jean, you didn't get your feedback. If day one doesn't resolve, well, how do you think about it?
Burn it all down. No, I was kidding. Yeah, I agree. Sometimes, sometimes certain cases are just ripe for like, this is the best day, because after today, then we're going to be taking all these depots and doing all this stuff or whatnot. But yeah, sometimes you get in the mediation and you say, this is the one dispute. It's the case is worth this, or it's worth this, depending on this one thing. And so let's go take that depo. Let's go get that order from that motion or whatnot. And then we'll revisit. Hopefully you've done some of that work beforehand when you're thinking about timing of the mediation, right? And so if you already know that there's a core dispute that's going to vastly change the value of the case, maybe you do that before, get a mediation scheduled, get that work done first, and then go to your mediation. But yeah, I agree. I think more and more cases are not settling that day. A lot of cases settle with a mediator's proposal. Maybe the parties need just some time, cooling off period, or time to discuss with whoever. So yeah, I agree that viewing it as a one and done is not accurate, I guess. Yeah.
It's not reflecting where we are today.
Yeah.
So we're almost at 1 o'clock. For anybody who can stay, I'm going to speak for Gian and Christine. Katie, can we stay on for like another 10 minutes or so?
Yeah, absolutely. I do just want to note that anybody who does have to hop off for, the end of your lunch break here, you will receive full CLE credit. As a reminder, those CLE certificates will go out via email within the next week. Please take a look in your spam folder or your junk folder to make sure it isn't caught there. And if you have any questions or don't receive that certificate, reach out to mcle@adrservices.com. As you leave the webinar, you will be directed to a short survey. We really do appreciate if you take a couple of minutes to fill that out. I read every single answer, as do our speakers, and we do love to see what you have in mind for any future programs so that we can really give you presentations that you're interested in learning about. So we do have a few more minutes here if you'd like to hang around. And Mark, I saw quite a few great questions here in the over here if you want to take.
I was just glancing quickly, and you're right, Katie, and thank you. So I think some of these actually got addressed by our comments, but here's one. Is there anything in the preparation stage that would differ when you have multi-party, either multiple plaintiffs or multiple defendants litigation? Gian, thoughts?
Oh, yeah, it's always tricky in my line of work, I guess, when there are multiple plaintiffs and multiple lawyers involved. Mm-hmm. Usually we're going after the same pot of money. But there's there are opportunities to obviously get on the same page with the other lawyers on your side and make sure you're not doing anything to harm each other. So you should have conversations with their lawyers as well. But it can be tricky depending on the case, right?
Christine?
Yeah, when I was in-house counsel, we would sometimes do joint defense agreements so that we could have those discussions. And I think that can be incredibly helpful for you to, at a minimum, know where you may have some divergence and what you're going to do to address it. It makes everybody's life a lot easier if you can work that stuff out in advance. I agree with that. So
yeah, my 2 cents is it somewhat a matter of the type of dispute and the scale. So I've been doing some mega disputes involving states in our union and Medicaid provider organizations where the underlying amounts in dispute are in the tens, if not the hundreds of billions of dollars. And given the scale, the complexity of those matters, I again, going back to one size does not fits all, came up with approaches that are customized per party because they had to be. And in fact, it was the mediations did not put everybody together for very important reasons. So it's really trying to going back to what are the goals, what are the objectives, what are we trying to accomplish here? Working backwards from that and stepping away, my 2 cents from this issue, it's just about a lawsuit and somebody's going to win, somebody's going to lose, to bigger picture things. So the more complicated the matter is in terms of number of parties, there's opportunities to take a step back or sometimes 3 steps back and set things on the right stage. That's why I love the work. It's just there's no one size fits all. So we addressed a couple. Do you require pre-mediation plaintiff's demands? We've done that. What does it signal when the other side doesn't present a brief? I have my own 2 cents, but Christina, if you don't get a brief on the other side?
At a minimum, I have to have a phone call with them. If somebody tells me they're too busy to write a brief, number one, that begs a lot of questions about how you're handling the case. There's always this is what we're doing for mediation, right? And it's part of preparing everyone. It's the 3 things we talked about: prepare your own client, prepare the other side, and prepare the mediator. Having said that, I get it. There's a lot of people who have high volume practices, and if you can at least just set aside, half hour, an hour with me on the call, at least I can get a sense from you of what the lay of the land is, where there may be some landmines. Are there some things, for example, on the plaintiff side, that are going to be particularly sensitive for that client? And if it's a really emotional case, what's the best way to handle it? Do they need their day in court? Are they going to want to tell me their story? Or is it the opposite, that they're going to not want to talk about it and they should just share it with me now and we just get to a few questions, in the mediation with that person? So there's a lot that I need to cover with them. On the defense side, similarly, I want to make sure that they've done the homework that they've needed to. I find most of the time, the defense is more likely, frankly, to hand in their brief. But sorry, there's my bias leaking out. I try not to be biased, but having been on the defense side, what I see more often, even as a mediator, is it's the plaintiff brief that doesn't get handed in. But again, it doesn't matter which side it is. What's most important is that there's communication with me, and that I'm able to then be a proper neutral to be able to work for both sides to get to a resolution.
Okay, so I got one for you, Gian. Do you find that plaintiffs tend to get upset if they see the corporate defendant's mediation brief and it negatively affects negotiation?
Oh, yeah. I don't know if this answer is going to get me in trouble. So, but if I find that it's not going to put them in the right headspace for negotiations, I won't share it with them directly. I will talk to them about what the likely defense arguments are going to be, or the defense arguments are, if I've actually seen the brief. And I want them to have that initial reaction with me ahead of time, so that it doesn't feel like such a blow in the mediation, and I can help them process that on our own before they hear it by some stranger, right? most of the time for these clients, like my employment clients, I don't actually share the actual brief with them because I don't think it's productive.
I think I may have misunderstood your question, Mark, now that I'm listening to Gian's answer. I thought you were saying that people just don't turn in briefs at all, as opposed to sharing the brief with your
No,
client.
I jumped ahead to another question
Oh, okay.
where I think the context is the brief gets shared, but the defendant's brief is does it negatively affect the negotiations? My 2 cents is this goes back to the tone and temperament. If you're writing a brief on either side that is fact specific, here are the facts. So and so did get 3 final written warnings, or no, there's evidence that everybody was using this information. It wasn't trade secret information. I want the other side, again, decision makers on plaintiff side, defense side, insurance companies, whatever, to see that information, and you can convey it as neutrally as possible. I'm not calling them names, but this is what you need for a trade secret. It doesn't exist here. This is what you need to make this kind of claim. It doesn't seem to exist here. So that is the risk, but I think it's frankly, it's responsibility of the advocates to tell their story in a way that doesn't, again, add invective, but says, but here's what happened. Let's see, we've got maybe another minute or two.
There's usually a lot of name calling, or like on my side. So it's not helpful most of the time for my clients to read that. I can certainly convey that, but sometimes it's not helpful to see it on the written page.
Well, there's many more questions than we have here, Katie. I think probably we really
Before you get into the last couple, I wanted to check with the three of you if it's okay if I drop your email addresses into the chat, just for anybody who we're not able to get to their questions.
Absolutely, because I think we have at least 27 questions, and they're all great. But
yes, thank you.
We may,
but yeah, I think we have time for maybe a couple more. I'd love to close at 1:10 just to be cognizant of everybody's afternoon.
So here's a short one. Some attorneys say no free discovery. How do you respond as the mediator? So first of all, my response as a mediator is, what do you mean? Discovery should be expensive? Why? If one side wants free discovery, no, my short answer is if one side wants free discovery, sure, and you provide free discovery back. That's what you should be doing. You should be exchanging, getting everything out on the table you can. It's not super secret. And what's wrong with that? I've had attorneys say I only go to mediations to get free discovery. I find a polite way of saying you shouldn't be doing this work. You're not helping your client by doing that. So again, my 2 cents, being inherently cheap, is to say, why do we have to pay for anything we don't need to? Why can't we just get it out there? But Gian, you would never say that. You don't just show up for free discovery.
No, yeah. I mean, I think I would challenge and say, what do you mean by that, right? What do you mean by free discovery? I do think that mediation, even if not successful in that first round, is an opportunity to just learn more about the case, right? So there are benefits even if you don't get to a deal that day. But yeah, I mean, if all the advocates are doing their jobs, they know what they need to do, and they know what information they need to get, and just having it presented informally in a mediation really doesn't, I mean, I don't think you're losing anything by that.
And you're going to get it eventually anyway. Right. That's what doesn't ever make sense to me, is I don't really see that it is as free discovery. First of all, you paid to be in the mediation. Second of all, you're going to get that information down the line if both advocates are doing their job well. They should be asking for it in discovery, and it should be produced later. So it's just a question of sequencing and timing of when you're getting that information.
Yeah,
exactly.
Fully agree. So we are at that magic time. Katie, thank you so much. Christine and Gian, it was terrific for me, and I love the exchange. And again, everyone is welcome, if they didn't get their question addressed, to reach out to us, and we'll respond. Okay.
Great. Yeah. Thank you, everybody. Thank you, Mark. Thank you, Christine. Thank you, Jan. And thank you, everybody who spent your afternoon with us.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront. Woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.